Hi everyone. If you bear with me, I'm going to try to share my slides. I'm just getting used to all this technology, so hopefully this will work. Is that okay? Great. I'm Aimee Fox. When I am not found in Education Tribunal, I can be found in either your local family court or your very far-flung family court, depending on which clerk I've upset that particular day. I started practicing in family law before my education practice developed. And I have to say that both areas of practice really complement each other. And certainly I found over the past 7 or 8 years, having a knowledge of education and special educational needs really helps if you're a family lawyer, and it really helps in the family court. The family court isn't as up to speed as the first tier tribunal in respect of diagnoses, types of placements, types of therapies. You often find even that your child protection social worker who's involved in the case might not have much awareness of special educational needs. So it's been really useful to have that background knowledge. I have started with some information. Back in 2010, the government was talking about promoting educational achievement for looked after children, and they issued some statutory guidance. I thought this paragraph really encapsulated the situation for children in care. Back then they said that looked after children are 9 times more likely to have a statement than the general population. The majority will have identified special educational needs, and they highlight the importance of making sure that children continue to be provided for from an education angle in their care. It's important as well that local authorities and social workers are really able to quickly identify which children in their care or who are coming into their care have special educational needs or may have special educational needs. I have put some more up-to-date information here, which has just been published at the end of March. It looks at the outcomes for children who are looked after, and it looks at where things stood in 2019. So we can see looked after children and children in need reaching the end of Key Stage 4 3 or 4 times more likely to have a special educational need than all children. In 2019, 55.9% of looked after children had a special educational need. They also gather information and categorize in terms of the type of need. So what we see for children who are looked after is usually and more commonly, the primary type of special educational need is social, emotional, and mental health. So that covered 40.4% of those with EHC plans and 47.5% of those with some form of support. You can see how the figures can contrast with the overall population, where the primary area of need in terms of social, emotional, and mental health was 13.3% for those with plans and 18.1% of those with SEN support. Some of you may have represented or helped people who have been in dispute with the local authority over educational provision, but then also have involvement or threatened involvement from the children's services side of the local authority. You may hear that a Section 47 investigation is taking place, and that it's probably something that's going to be new to your client. It happens when the local authority is just initially getting involved. And I wanted to set out Section 47 of the Children Act, which is where we get the Section 47 investigation title from. So where a local authority is informed that a child in their area is subject to an emergency protection order or is in police protection, or where the authority has reasonable cause to suspect a child is suffering or likely to suffer significant harm, they will start to make their inquiries. They'll also do it where they have obtained an emergency protection order, that they'll undertake their inquiries. So if you hear a client say, I've been told there's going to be a Section 47 investigation, that's where the power to carry out that investigation derives from. In family, we talk about care proceedings. Those are proceedings involving usually the local authority as the applicant applying for an order in respect of the subject child, parent or both parents, and also a guardian is appointed to represent the child effectively, and the guardian is a specialist social worker who is independent from the parents and independent from the local authority. The guardian's voice carries a lot of weight in the family court because of that sense of independence and the voice of the child. If you have all of those characters involved, you are likely to be in care proceedings, and the local authority is likely to have applied to the court for one or other type of order. What we see is Section 31 of the Children Act. That's the gateway to placing a child with an authority, or putting the child under the supervision of an authority. Both of those orders are care orders and supervision orders. And at 2B, you see the court's threshold. If the court is satisfied that the child is suffering or likely to suffer significant harm, and the harm or likelihood of the harm is attributable to the care given, or the child being under beyond parental control, then the court is likely to make an order. The wording in Section 2A, suffering or likely to suffer significant harm, that's terminology that you will hear time and time again in the family court, and that's often the test that we are looking at applying and seeing whether the particular facts of the case meet that criteria. It's obviously fact specific in every case. The subsection 2, Roman numeral 2, the child being beyond parental control, is another one to be mindful of, particularly if there is a child or a teenager with such a level of need that it's very difficult for the parents to cope with. And for example, perhaps the child is absconding, perhaps the child is out late at night, then the local authority may well be getting involved. The court doesn't make a care order or supervision order in respect of a child who's reached 17 or 16 in the case of a child who's married. So Section 31 is a really important section of the Children Act, used time and time again. Section 44 of the Children Act I'd like to just touch upon briefly, because it deals with emergency protection orders. and that's where there's reasonable cause to believe the child is likely to suffer harm, and it's about a very urgent situation. Usually we find these types of applications being made on very, very short notice. One aspect of this section to be mindful of is the very final point, which is subsection B, Roman numeral 2. A local authority may try to obtain an emergency protection order if inquiries are being frustrated. So if their access to the child is being refused where they don't think it should be, then they are likely to act and ask the court to sanction the making of an order. I don't think in education terms refusing an assessment from the local authority's EP or OT when you're in the midst of tribunal proceedings is what that subsection is getting at. In my view, it really needs to be something rather more than that. I've certainly never had a local authority try to get an emergency protection order because I say the local authority's far too late in the day and they can't have their EP coming in, or the child has been over-assessed. So that's not one to be unduly concerned about. Again, highlighting here at C3 about the urgency of the situation, that this access is being refused to the child, and believing that access is required as a matter of urgency. So you might think of a scenario where a child is perhaps not attending school. That's unusual, it's out of character. There are concerns about abuse in the household, or there's concerns about neglect, and the local authority very much wants to get in on an urgent basis to check everything's all right with the child. So the types of orders that the family court can make, I've already touched upon. We have the emergency protection order, so quite short-term orders. We have an interim care order where the child is suffering harm or likely to suffer harm. That interim care order allows the local authority to share parental responsibility for the child. You can have interim care orders being made at the outset of proceedings with or without removal of the child. You may theoretically have an interim care order made where the LA shares parental responsibility, but the child's still at home. A lot of local authorities don't like that because it exposes them to risk. If anything happens to the child in that household and they've got PR, then they're really exposing themselves to criticism. So an interim care order also allows an authority to remove a child into foster care or another type of placement. Both of these types of orders, EPOs and ICOs, are made or can be made on very short notice. Sometimes you find yourself getting a set of papers and being in court that afternoon, or picking up the papers on the way to court. So they are dealt with very swiftly. They are not a final determination. Care proceedings should theoretically follow a 26-week timetable, where the local authority can ask for a final care order to be made, where they will continue to have PR. They might ask for a placement order to be made that allows the local authority to place a child for adoption, but that ought only to be granted if they have a final care order. They might get a supervision order, which doesn't give them PR, but does place a duty on them to advise, assist, and befriend the child. Or you might have a special guardianship order, where someone steps in as the child's special guardian. Sometimes it's another family member, and that confers PR on that special guardian, the person who the child will be living with, and that can be used to the exclusion of parents. The other type of order that can be made, of course, is no order. If you have successfully represented parents and convinced the court that there is no need for local authority intervention, then the no order principle would apply. I'd like to focus a bit more on the alternative to care proceedings, because not every scenario where a local authority is involved will end up going through the court process. So what is that? We look there at Section 20 of the Children Act. That doesn't give the local authority the same power as an interim care order would give, or a final care order. So that's a duty on the local authority to provide accommodation for children, for example, where there's no one with PR, the child's lost or abandoned, or the person who's been caring for him is prevented from providing him or her with suitable accommodation. And also duty on the local authority to provide accommodation for any child in need within their area who's reached the age of 16 and whose welfare would be prejudiced if the authority didn't accommodate. So a local authority may provide accommodation for a child in their area if they consider to do so would safeguard or promote the child's welfare. They certainly don't have to, that's optional. And they may provide accommodation for anyone who's reached the age of 16 but is under 21 in any community home if they consider that would safeguard and promote welfare. Section 20 goes on. It goes on to Section 7, which is when the local authority may not provide accommodation. Local authority may not provide accommodation for a child or a young person if the person who has PR is willing and able to provide accommodation, or is able to arrange accommodation for him. So if the parent objects, they cannot exercise their powers under Section 20. Section 20 allows a withdrawal mechanism. You don't give any notice. If you have delegated your parental responsibility to a local authority to accommodate a young person or child, you may at any time remove the child from accommodation. Be warned, though, that that might trigger the local authority issuing proceedings and applying to the court for an interim care order. Why is Section 20 important with children with special educational needs? The court will ask itself whether or not the child is suffering or harm, or likely to be suffering harm. The local authority child protection team may not appreciate the nuances of special educational needs. You can imagine a scenario where a child is complying all day in school, doing okay in school, but then you hear of real difficulties in the house, potentially beyond parental control, or meltdowns or violence in the home. What you don't want is the assumption to be that that's your client's parenting. What they may not understand is, if I take, for example, autism, that a child might be able to cope during the school day, but will have put so much effort into coping that that release whenever they come home is potentially towards parents or carers. It doesn't necessarily mean that the parent or carer isn't providing for that child properly. So it's about understanding whether behaviour is coming from a special educational need, whether it's parenting or lack of parenting, or potentially whether it's both. And you might have families who are really struggling to cope with a child or family member approached by the local authority to agree to Section 20 accommodation, to effectively delegate their parenting to the local authority without the need for the local authority to go and jump through the hoops of going to the family court and obtaining an order. We have had very recently some guidance from the Supreme Court in respect of Section 20. It's Williams and the London Borough of Hackney. The use of Section 20, they remind us, is an interference with Article 8 rights. It's got to be in accordance with the law. It's got to be a proportionate means of achieving a legitimate aim. The really important thing about Section 20 is how agreement is reached or how the PR is delegated. There are some authorities from years ago of, for example, a woman being approached on the maternity ward on the day she'd given birth and gone through surgery. I understand that the surgery also involved morphine. Being asked to agree to that baby being accommodated under Section 20, that's not appropriate. Parents and carers need to be informed of their rights. They need to understand how Section 20 works and what they are agreeing to. So this case from the Supreme Court really helps us with that. There have been, over the past few years, quite a number of cases where local authorities have been sued for damages for inappropriate use of Section 20. We had previously children on Section 20 accommodation for many years. Some felt that was inappropriate. So Williams reminds us there in the bottom line, of course, of what we have seen, that damages can be awarded for inappropriate use. The court really assisted Williams with setting out 9 points about Section 20. The starting point is parental responsibility. A parent can, of course, delegate parental responsibility. We all used to talk about consent. In fact, I've probably talked about consent and agreeing this afternoon to you. They want us to move away from that and find the idea of consent to Section 20 confusing. We're supposed to talk about delegating your PR, and that delegation must be real and it must be voluntary. They say at point 3, removing a child from a family home is different to stepping into the breach when the child's not being looked after. That doesn't require active consent. There is an emphasis throughout this whole judgment on parents being informed of their rights. And I think it's because of historically the problem that people have seen with Section 20 and it being felt that there's been an inappropriate use of it, that people haven't quite known what they were signing up to and perhaps felt under pressure from children's services that if they didn't go along with this, something would happen, but they weren't quite sure what. On the flip side, a parent can ask a local authority to accommodate a child as part of services for children in need. I've certainly been involved in tribunal cases where by the time that we're approaching tribunal date, parents have asked for a child to be voluntarily accommodated. And of course that might change the landscape depending on where the child's placed. Williams reminds us that a local authority cannot accommodate if someone with PR is willing and able to do so, or to arrange for somebody else to do so. If the local authority considers that those arrangements are unsuitable, they should be applying for an emergency protection order. Williams reminds us a parent can remove a child from Section 20 at any time, no need to give notice, and the local authority must return the child unless it's necessary to take steps to protect the child from being physically harmed. So one example would be perhaps a parent attending foster care or the place where the child's residing, perhaps in drink or in alcohol and a danger to the child. Of course, in that scenario, the local authority is not going to allow the child to go with someone who's posing a real risk to them. If there's a child arrangements order stating with whom the child's to live, a special guardianship order, or an order under the inherent jurisdiction of the High Court, those will limit the ability of the parent to object, or perhaps better put is limit the weight that will be attached to their objection, because if those people agree to Section 20 accommodation, it can happen. Once a young person's 16, a parent can't remove that child if that child is wishing to continue to be accommodated under Section 20. Williams says there's no limit on the length of time for which Section 20 can be used, but we've got to be mindful of how much criticism there has been of local authorities keeping children on Section 20 really long term, and Williams reminds us that the length of time that you use Section 20 might be unreasonable in public law principles, or it might be a breach of Article 8 rights or other regulations. I've also put in a slightly older case. It's a 2011 called repeal case. It predates the Children and Families Act, and it certainly predates Williams and some of the more recent authorities on Section 20. But I think it's interesting because it looks at Section 20 from another angle. And this case did involve a child with special educational needs. O was the child involved, diagnoses of ASD and ADHD, family been receiving some respite care. Then it was decided he would go off to a specialist residential school and come back at weekends. What the local authority wanted to do there was to terminate Section 20, because from their point of view, everything's now sorted. O was going to a specialist residential school, everything's going to be catered for. Why did there need to be Section 20? The court found that the authority's decision to terminate Section 20 was unlawful, and local authorities have to be a little bit careful about simply assuming that because a child is in a residential school that Section 20 is no longer applicable. Section 20 duties, according to this case, can continue when a child's placed in a residential setting. Whether the placement is wholly, it depends on whether it's wholly or mainly to meet his or her educational needs. So a child can retain looked after status whilst attending a specialist residential educational setting. Doesn't necessarily extinguish the Section 20 duties. That's quite important because looked after status can come with entitlement. That young person, when leaving care, may receive a leaving care package. So it's important to be aware of the various entitlements, not just looking at education in isolation. The useful extract from this case I've put in, it was from paragraph 80. They refer back to a previous House of Lords case. Short shrift is to be given to any claim by an authority that a child who requires accommodation within Section 20 can be deprived of lax status by being provided with accommodation under another statute or label. So we really see Section 20 coming into play at two ends of a spectrum. One, where the local authority is trying to remove a child or accommodate a child without having to jump through those court hoops. And at the other end of the spectrum, where they're then trying to back away and thinking, well, we don't really want to have to continue with are visits to the child and the social care element of things. It's all education now. So I think that Section 20 is something to be alive to. It is not unknown for it to crop up where there are special educational needs, and it's important to be able to manage what the local authority is trying to achieve, the use of Section 20 and whether it's appropriate, if PR is to be delegated, if the family or parents are informed, know what they're signing up to, best practice that it's in writing and everyone understands it. And if the local authority is wanting to remove Section 20 and you don't want them to do that, there is an argument to be had in some cases. And finally, if families find themselves in a really unfortunate position of being involved with care proceedings, that the family court may not have as much of an appreciation of special educational needs as those of you here today, and also our tribunal judges. Sometimes you just have to show them the way home and don't take for granted that they're going to have an intricate knowledge of it, or even a knowledge of tribunal or specialist settings, and that your child protection social worker might not have that knowledge either. And not forgetting, finally, not to assume that children's services and the education side of the local authority are necessarily talking to each other. So I hope that was just a helpful whistle-stop tour into the family court jurisdiction and some of the different types of orders. I think we're going to possibly move on to some questions. So if anyone has any, I'll try to deal with them. Thanks.